3, 2, 1, start. Rule 49 and Rule 55A, withholding of one increment with cumulative effect punishment held by the writ court as minor and not major, and accordingly such punishment can be meted out after taking recourse to Rule 55A. That is, punishment can be awarded without making inquiry as elaborated in Rule 55 in the rules. There is no concept of either minor punishment or major punishment. It only provides what punishment can be awarded, and to award what punishment, what procedure is to be followed to withhold increment. Procedure prescribed in Rule 55A can be adopted. Withholding of increment cannot be equated with withholding of increment with cumulative effect, because the effect of withholding of one increment with cumulative effect would have the same result as that of reduction to a lower stage in a time scale as mentioned in Rule 49, and for inflictment of such punishment the only method prescribed to be adopted has been furnished in Rule 55, that is, it requires an inquiry and conclusion of the matter. After inquiry, writ court erred in holding that such punishment can be awarded by taking recourse to Rule 55A. Bihar Pension Rules 1950, in cases in which proceedings of Rules 1930 had been initiated prior to the retirement of the incumbent, the same procedure ought to have been applied while proceeding of pension rules. Impugned punishment of reduction in pension was passed without holding full-fledged inquiry. 55 of the rules. 1930. Impugned order not sustainable. Full stop. Rule 55. Punishment inflicted of no payment of salary for the period of suspension beyond subsistence allowance. Inflicting such punishment after retirement of service cannot be sustained. Any punishment in a pending departmental proceeding in terms of Rule 55 cannot be passed, as such punishment must be confined to the provisions of Bihar pension rules. The state government could only pass an order of punishment in withholding payment of pension, recovery of the amount of loss sustained by the government. The respondents directed to pay the full salary after deducting the amount of subsistence allowance already paid to him. Full stop. Section 2. Application for temporary injunction filed by the plaintiff number 2 as chela of plaintiff number 1. Application was rejected on the ground that he failed to show sources deriving interest in the sued property for establishing prima facie case issue is with regard to the competency of plaintiff number 2 to carry on the suit. In the plaint itself, he is arraigned as plaintiff number 2, and clear statement has been made that he is looking after the property of plaintiff number 1. It is now immaterial that the plaintiff number 2 has succeeded or not succeeded as Mahant and Chela in succession of plaintiff number 1. Further, in view of the clear provisions of Section 2 of the Code, an intermediary is also a legal representative, and as such, the plaintiff number 2 has the right to continue the suit not on his own behalf but on behalf of the estate of plaintiff number 1. The reference of personal interest of the plaintiff under Section 41 of the Specific Relief Act would not refer to the personal interest of the plaintiff number 2, but personal interest of plaintiff number 1, which interest would now cover the estate of deceased plaintiff number 1. Plaintiff number 2 is entitled to maintain the application. Full stop.